Hi, welcome everyone to the webinar Privacy Policy, What Happened in California and What is Happening in Congress. I'd like to welcome you to today's webinar, and we're going to go ahead and get started. Next slide, please. Today's agenda, we're going to go through some housekeeping items, introduce the presenters, talk a little bit about Conexxus, and then we'll have some time for questions and answers during and after the presentation. So this webinar is being recorded and will be made available in approximately 15 days. This webinar, as well as all of our past webinars, can be found on our YouTube channel at youtube.com/ConexxusOnline. They're also available on our website. Approximately 1 hour after the webinar, an email will be sent out with a link to a survey. It's very short, about 4 questions, just to get some feedback about this webinar. And if you complete the survey, a slide deck will be made available to you. Participants are encouraged to ask questions via the webinar interface. We'll be monitoring those throughout the webinar to accept questions. And we do ask that you do not ask any vendor-specific questions. Our webinars may be used towards PCI continuing education credits. So if you're interested in a certificate of webinar attendance, please email me at arussell@conexxus.org. Or if you have any general questions, feel free to email us anytime at info@conexxus.org. I am your Conexxus host and moderator today. I'm Allie Russell, and our speakers are Alan Thiemann, the General Counsel of Conexxus, and Paige Anderson, Director of Government Relations for MAX. A little bit about Conexxus. We are an independent, nonprofit, member-driven technology organization setting standards in data exchange, security, and mobile commerce. We provide vision to identify emerging technology and trends and advocate for our industry, believing technology is policy. This was our webinar schedule from this past year. If you're interested in any of these topics, we encourage you to go to our YouTube channel or our website where all of these webinar recordings live. And in November, we'll have Sam Fansteel from Control Scan with applicability of PCI DSS requirements for merchants and MNSPs. December 5th and 12th, we're having a 2-part series on EMV. The first one will be held on December 5th with Linda Toth of Conexxus, Brian Russell of Verifone, and Robert Alden from Visa. And the second part of that EMV series will be on December 12th with Gray Taylor of Conexxus and dispenser manufacturers. Next slide. Conexxus has a conference every year. In 2020, it will be April 26th through the 30th at the Lowe's Montana Canyon Resort in Tucson, Arizona. We'd like to thank our 2019 annual Diamond sponsors. And if you have any questions about the Conexxus annual conference, please feel free to reach out to us or visit our website. And with that, I'd like to throw it over to our presenters, Paige and Alan. Thank you both so much for presenting this, and we're looking forward to it.
Thank you, Allie. We're glad to be here. Privacy has really taken on a new level of importance amongst lawmakers, both at the state and federal level. The buzzwords that we had been hearing before had been all about data security and data breaches, but over time it's really migrated into an overall privacy discussion. And what do we mean by privacy? You know, a lot of times, just figuring out how we define terms and making sure everybody's defining what we're talking about in the same way is so important to be able to understand these issues and to be able to create laws surrounding privacy. But basically what most lawmakers and regulators are looking at under the privacy discussion is, okay, what information should be protected? Who should have that information? How do we use it? And how do we take care of it? Unfortunately, there have been some data brokers and data collectors in the news that have not necessarily handled people's information in the way that they should be. I think that's a diplomatic way of putting it. And so consequently, that gets a lot of news, and therefore politicians look at the news and everybody's up in angst, and now we're in crisis mode that we have to do something regarding privacy. But really where a lot of the activity, though, there is activity happening at the federal level, really it's been the states that have really taken this over and really moved a lot of the discussion and actually have created laws. And And which is because of that, we thought it would be important because California really is the most comprehensive privacy legislative and regulatory model that we've seen across all the 50 states. It's about to be implemented in January. We felt spending some time today to go over what happened in California, because for better or worse, what happens in California tends to spread to other states and even at the federal level. So it's so important that we understand what happened, what is happening, and what may happen in the future with California. So that's why we're going to devote most of our discussion today with that. And then at the end, we'll go into what's happening at the federal level. So I'm going to hand it over to Alan, because you have been, I won't say you've been underwater in privacy, but you've certainly been spending the majority of your time figuring out this complex law.
Yeah, I'm having a hard time seeing above the water. Well, as you put it so appropriately, Paige, California almost right now is the default state law. And we're going to talk later on about what may be happening beginning in the next legislative session around the country and federally. But let's just kind of get into the issues of what happened in California. So the law was passed actually in 2018, in June of 2018, but the ability to enforce the law has not been there yet. And as you indicated, it's coming up January 1st of 2020. So let me just give you a couple of quick reference points. I don't know how many folks in the audience may have already had to deal with the General Data Protection Regulation out of the EU, but there are some similarities, but there are a lot of differences. And I've tried to highlight a few of those here in the first slide. By the way, I'm not going to go read through these slides. We've got lots of other information that kind of bears on these points. But I do want to mention that GDPR is primarily organized around getting informed consent from the person whose data you're trying to collect and use, whereas the California law is really more about informing consumers of what you have collected and used over the past 12 months. So it's almost really backwards looking as opposed to future. And I should also point out that California is really principally an opt-out law, whereas GDPR is clearly an opt-in. So those are a lot of the differences, and a lot of that will become clear as we get into talking about more of the details. So the landscape, a lot of what the GDPR is intended to, or the CCPA is intended to do, is to provide the transparent way for consumers to know what's being collected and how it's being used by any business. Although in California, it does only apply to for-profit businesses. A lot of the data protection issues you mentioned are still part of CCPA. Data breach notifications. We'll talk a little bit about what happens in those situations, giving notice of any breaches. But more importantly to the conversation is the package of consumer rights that have been built into CCPA. And let's take a little bit of a look at some of those. So again, effective January 1st, there are a host of rights. We'll go through these in a little bit. But what you're really looking at is the need to have a proactive approach in what you're doing to protect your businesses from any enforcement problems. And we're going to do a checklist of some of those activities near the end of the presentation. But you need to be considering what you've done today currently with your privacy policy, and make sure that that privacy policy conforms to these new rules and rights that exist for consumers in California.
And I know you're going to go into this in a little bit, but I think it's important to know there may be some folks listening who maybe are not based in California, but they may be doing business in California. And it's just as important for those folks to understand what's going on just because you're not based in there, but if you're doing business, you have to understand what these laws and rules are.
Well, let me jump ahead a little bit because you're right where I have a slide on what the coverage, what the eligibility requirements are. So let's basically take a look at that. So yes, if you're doing business in California, that's the principal qualification. If you're collecting personal information on California residents, California consumers, you're right in the crosshairs. There are a couple of tests, thresholds that exist that will tell you whether you have any chance of avoiding any of these requirements that we're going to be talking about. One of them is revenues of less than $25 million. There's a huge question about what that limit refers to, total gross revenues, but is that revenues in California or worldwide potentially? There's a lot of debate going on. There was a lot of debate prior to the implementation regulations being issued in October, and unfortunately the regulations don't even address that question. So while it's been a hot topic, if you will, what really qualifies, the truth of the matter is it's a little unclear. I'm making an argument for a client that the California revenue is obviously the direct relationship to the covered requirements, and therefore it ought to be limited to California revenue. But I've heard people talk about saying, well, the other two requirements about California consumers and doing business in California, that the legislators in California well knew how to limit it to California. And if they wanted to, they would have put California revenue in here. So there's an equally valid argument going on that it doesn't matter about 25 million being California revenue. It's probably going to be any revenue you have. More importantly, the other threshold that you need to look at is 50,000 records of California consumers. How do you get to that 50,000? How do you know whether you have 50,000? So there are issues there that you have to pay attention to. And by the way, the important one is that it covers, and you'll see on the note that I have here on the slide, any combination of your business with its affiliates or subsidiaries or parents are treated. If you're under one brand, you are basically one entity for the purposes of those 50,000 records. I have a colleague who's been going around the country talking to different corporations who have issues about, do we really want to keep one brand when we might actually have subsidiaries that are under the 50,000 record limit? And so there's actually work going on here among corporate folks in the United States to address their corporate structure because of this 50,000 record limit.
So you could be, a 1 or 2 store operator, but say you have a mobile app, and as you build followers to this to your mobile app to get these deals, you could very well hit that threshold fairly easily. Or if you're in a high traffic area, every transaction counts as a record, correct?
Yeah, the size of the business isn't the test. It's how many records.
And that could be a credit card transaction. That could be social media followers. There's a whole host of different.
And participation in loyalty programs.
Yep.
Yeah, so 50,000 sounds a pretty big number, but it's not.
It's not.
Particularly when you, as you pointed out, social media approaches today, you end up with way more than 50,000 people potentially following you or participating in your programs. So yeah, I'd be, this is not a question where I'm so small I don't have to worry about this. And it's also a case of you don't have to worry about it if you're outside of California, even if you're not doing business in California. If you have California records in your files,
you have to pay attention.
You're going to have to pay attention.
Hey guys, we do have a question. What is the definition of personal information, since so much of this information might already be in the public domain?
Well, public domain information is partly exempt, but the list of what is covered in of the qualified personal information is exceedingly broad. I thought I had a list of it here, but I see I don't. So it's literally the laundry list covered in the California state code of, name, address, social security number, email address, postal address, all of those usual suspects. But then it goes on to talk about a whole host of other information, biometric information, any financial information. So health information is one of those exemptions. Do I have a slide on this?
You sure do.
Oh, there we go. Okay, so, but it doesn't really talk about what's under the definition of personal information. So the question really is pretty appropriate to say it's a real long laundry list of things that are identifiable to a person. And the one amendment that came up in September when the California Senate finally passed some amendments in September, the only help that you get on definition is it said that the information has to be reasonably related to identifying a person.
So just because information's made public in the public domain doesn't necessarily mean it's exempted, because you also have to look a combination. While your name itself may not be as vital, but your name connected with your birth date, or your name with your address, or your name with your social, all of that information, could potentially, if paired with another piece of personal information, could make
Correct.
It fall under
that's
this.
this reasonably identifiable approach page, right? The original language in the bill just said related to, but they did amend it to say reasonably related. So arguably there's a little bit of flexibility there in determining whether one or two pieces of information really do result in an identification of that individual. And I should also point out, it's not just the individual, it's the household for that individual.
Okay.
So information about buying habits and all of that stuff, if there is an ability to profile not only the individual, but the household,
right,
that is pretty much expected to be covered.
Okay. That's very broad.
Very broad, very broad. So let's go back to this one. So what are the rights? Importantly, it's okay to say, here's what the personal information is. What does that then translate to under the law? So there are basically three rights that a consumer has under the California law. One is the right to know or get access to the information you've collected and used. And again, usually this is now going to be defined as over the past 12 months. The ability for the consumer to request that information, what you have, what categories of information you have, and who you shared it with. And then the second right is the request that a consumer can make to correct or to delete the information. So if I don't want to have that information put out there to anyone, or I want you to stop collecting and using my information, there's a process here in California to require a business who gets a request to delete to act on that. And the third big right that is really probably the hallmark of this whole legislation is called the right to opt out. Okay, so if I don't want you to sell my data as a business that I'm doing business with, there's now a requirement in California that you put a do not sell button on your website, or if you're a brick and mortar business, you have to provide a way to enable a consumer to act on this opt-out opportunity and to tell you, I don't want you to sell my data anymore.
So I may be jumping ahead a little bit. So you're a business and you have your do not sell button, do not share, but you've done what you're supposed to do. But oftentimes, especially in our industry, we don't save or control that personal information. We may have a third party that's doing it for us. And so we collect that information, the consumer, say they want to opt out or they put the do not sell. We let our vendor who has this information, we contact them and tell them, hey, this person is on the do not sell list. But what if they ignore what we shared with them? Are we on the hook for the enforcement mechanisms for California?
Well, you raised a couple of points. Number one, do not sell. Does not mean sell. Sell means share, disclose. It's a
broad term.
A very broad term. And so when you correctly use the example of I shared this information with a third party. Now, the real question that I keep trying to raise with the Attorney General, I'm not making kind of headway with this that I'd like to yet, and by comparison to GDPR, it's real clear that if you're the controller of the data, if you're controlling what you collect and how you use it, you have higher burdens than if you're just a processor who is like an agent or a contractor, service provider, which is the term that's used in the California law. If you're a service provider, you're really taking direction from somebody who controlled the collection and use of that information initially. But if it's shared with you, you now have an obligation. If the covered business comes to you and says, I've had an opt-out, do not sell from this consumer, you have an obligation to follow that.
Unless you've been expressly exempted.
Unless it's an exempt situation, or there is one new clarification that came out in September that is very helpful in some areas, and so for some industries. I don't know that it's going to be completely helpful in all instances for our retailers. If the information is de-identified, in other words, you get it, but you take away from the collection of data sufficient information from which the individual can be identified. If you're doing that, you are well on your way to avoiding some of the problems.
So we have another question, wondering if this do not sell and opt-out options apply to the sharing of information with business partners.
Business partners, well, let me go to that one. Okay, so one of the things that happened in September, there were two moratoria, 2 one-year delays that were put into play. One of them deals with business contact information. So I'm not sure if that's the gist of the question, but let me treat it that way. So if you're selling products or services to another business, if it's a B2B situation, and you get information from a contact person from that buyer, that purchaser of your goods and services, or a vendor, and you're giving the information to a vendor, you want to be able to have a point of contact, and that is a business relationship, not a consumer relationship. And so for the next year, at least for 2020, the legislature couldn't decide what to do how to fix that perceived problem So for 1 year, you don't have to deal with CCPA requirements and notices and requests. But the advice that I'll give people is you really need to be real crystal clear when you're dealing with business contacts, not to monetize that in any way or go use that information for some kind of purpose other than the transactional business relationship. The other 1 year moratorium has to do with employee data. So unlike GDPR, where employees are considered to be individuals because it's not a consumer-oriented regulation, in California, employees were going to be covered as individuals with the same kind of problems being addressed and debated long and hard about, well, I have information on my employees that I need to keep for employment purposes and tax purposes and every other thing out there that's legitimate. Do I have to give my employees notice of their rights as a consumer? They're not consuming anything when they're working for me. If they buy stuff from me, that may be a consumer transaction, but just having an employment relationship, so the argument went, shouldn't translate to privacy requirements, privacy rights. So again, for 1 year, for 2020, the legislature enacted a moratorium to give itself another year to figure this one out. So what you really need to do for employees is you need a notice that explains this situation pretty clearly so that employees are not under the mistaken belief that they have rights, but they are not being ignored. You're telling them what's going on during this interim period.
So I know you have a lot of detailed information in these slides that if people do the survey work, they're going to get to. It might be good to jump to steps that a merchant needs to take.
Right.
And it sounds like there's a lot our folks have to do.
Yeah, I mean, unfortunately, it depends on where you are in the mix. How much have you done historically, and have you done anything because of the EU privacy laws? If you have exposure to any EU issues, you may have already begun to do some of this work. But I think I can distill down for you pretty clearly the kinds of things you ought to be looking at. You need to know where personal information is in your business, where in the flows, what databases that you have in your business where any personal information can be found. And by the way, PCI sort of does the same thing for financial payment card information. So similar to the drill that you probably had to do with regard to PCI, you need to now do that same drill with respect to privacy laws in California. Figure out where the data is, what databases exist in your systems, and how you're using the data. Why do you do this? Well, for two reasons. One, you need to decide, do you really need personal information for each one of these activities and put them in different databases? Can you minimize the data you're collecting? And then number two is you really want to be able to find out, if you get a request from a consumer for what information have you got on me, you need to know what databases to go search to respond to that request. Okay, so number one is the data flow analysis. Two, you really need to take a look at all of your notices and privacies. You really need to look at that privacy policy that you might have already put up on a website or have available for customers and clients. You need to look hard at that privacy policy because it has to be a transparent, easy to read, easy to understand, lack of legalese. So as a lawyer, that's obviously a big issue.
That's kind of hard.
It's hard for us lawyers to get away from legalese. So you need to look hard at your privacy policy and examine, whether you're disclosing all the right pieces of information. And there's a whole section in the regulations that deals with this. So I mentioned with the data flow, getting requests for that information, you need to have a procedure in place in your business to accept those requests. Okay, and even how to allow a consumer to make a request of you. Again, if you're online, if you have a website presence, you can do a web form. But if you're brick and mortar, the regulations say you must provide a mechanism for consumers to make that request of you at a store. I mean, this is a terrible burden, frankly. It's not something that I think is a smart move. In fact, one of the pieces of the regulation is you have to provide a toll-free phone line to do this. And I'm thinking, okay, I call in and I have to either talk to a person or I have to leave a voicemail message with my information of what I'm asking for. And by the way, there's a verification process that a business is supposed to go through before they can respond to the request. You have to verify that the person is in fact the person who's making the request. How do you do that? Well, you have to get information that allows you to match with, say, an account number or other factors of this individual to say, yeah, that is Alan Thiemann that's making this request to know what information I have on him and how I've used it. So I have to give some of that information up. If I'm doing that on a telephone 800 number to a live person or to a voicemail, somebody's got to transcribe that. That's the biggest source of errors ever in data entry. And now the business has a phone record of that data, which is adding immeasurably to the amount of information I've got on this person. And by the way, you have 45 days from the date of the request receipt to act on it. You can give a bit of an extension if you do the right things, but 45 days is basically the timeline that you have. So you need a process and a set of procedures in place for your business today as to how you're going to handle requests to know, requests to delete, and requests to opt out.
It sounds like some creative business folks there may be a new cottage industry on trying to comply with California.
Well, there are some software vendors out there that I think have done just exactly that. I certainly can't shill for anyone, but I think there are attempts to try to get a product out there to help a business deal with that.
Hey, Alan. So I have a question. Some privacy attorneys have said that the GDPR has provisions that when you're trying to verify somebody's information, if all they're asking for is deletion of email address and home address, the information you gather from them to verify their identity can't be more extreme than that. For example, you can't ask them for their email address and social security number to identify who they are. Is there anything similar in the CCPA?
Yes, some similarities. Again, differences between requests to know what information and requests to delete information. They are treated differently in the regs, but the verification process is pretty much the same. If it's a password protected account, then you really can use that password information to say, yeah, that's the person who has the account. There is a little bit of a tweak in California, some language that I frankly don't find to be at all helpful, that you almost have to re-verify with the individual that information, even if they're using the online password and it's correct. There seems to be some indication in the new regs that you have to do more than that. It's also bizarre if you can use a password online account to change the password, and there's no verification required anywhere in that context, why do you now have to do something more than just match the password to make a requirement or make a response to a request? All right, well, the last one I want to talk about, Paige, and then I think we probably want to move to some of the state and federal issues. If you have third-party contracts with any of the entities that you might be dealing with, you really need to go through all of those contracts and make sure that as you're sharing information with any of those vendors, that you're doing so in a way that's consistent with the CCPA, and that they, as the recipient of that information, know that they have an obligation to handle it properly. So it's a contract review that needs to occur. And for many businesses, and not just in petroleum, I mean, that's a host of contracts, host of relationships that have to be examined to make sure that as you're trying to deal with your partners, service providers, vendors, contractors, any number of different sources of those contracts, that everybody is aware of the requirements and ready to follow them. And as a business who's collecting the information up front and sharing it, many of you will have to ensure that the obligations that are given to a service provider contractor are such that you're requiring compliance on their part, or the agreement can be terminated, and liability and so forth, and indemnification provisions. I'll leave that to your lawyers to advise you on all the points that have to go in there on contract review. But amazingly lengthy process probably to get ready for most of us. Okay, so here's the information on the employment situation to do a notice, and for business contacts to minimize any commercial sale. A little bit on data flow analysis and data inventory. Here's some issues, some things you can look at for your privacy policy to make sure that it's covering all the things you need to cover. One last big point for a quick discussion: financial services. CCPA said initially that if you have a discriminatory pricing on products and services that is based on the use of personal information, that would be illegal under the law. That has morphed a little bit into it's illegal unless you take certain steps. And there was a proposed bill that was going to actually allow loyalty programs to be exempt under CCPA. That bill was pulled in September from consideration. I'm told that the sponsor intends to bring it back next year, but for 2020, the new regulations place a real requirement on anybody who has a loyalty program to follow these steps about what you have to notice, and each financial incentive has to have a good faith estimate of the value to the business of that incentive.
So you've got more information here to share, but one thing that's important is, California, while it goes into effect in January, there's certainly a lot of other states that have passed smaller, maybe less comprehensive bills, but are just as important because they could potentially be models at federal legislation. But just a few of the states that we're definitely seeing activity. Washington, it's going to be a big legislative year. There's a big momentum to push something early in 2020.
Modeled almost exclusively on CCPA.
Yep. You've got states like New York and Massachusetts and Maryland and Rhode Island on the East Coast. that are trying to pass similar legislation. Even Texas and Mississippi are looking at the California law. So understanding what's happening in California, like a virus, is going to be spreading to other states, unfortunately. So it's coming. 2020 is going to be, I think, a very active legislative calendar at the state level on privacy laws.
Yeah, at least a dozen or 16 states, I would say, for sure.
So that's the state level. Now we get into federal privacy law, and not just because it's in TV and on the news, all of these different violations of data security and privacy and how we handle personal information. But there's also a factor, particularly with companies that operate or have customers or are handling data in multiple states, having a checkerboard of all these 50 different privacy laws and standards becomes problematic. And because of that, there's a real push to have federal legislation and a federal privacy law, so that you would only have really one law that you would have to follow. So that's really kind of a push to have, one of the major drivers for a lot of folks in different industries, to have a federal law. But I want to take a step back a little bit in looking at federal, what's happening at the federal level. I want to look at the political landscape a little bit to keep in mind for the likelihood of a law. I want to look at sort of the playing field and the players, and then I'll give you a quick House and Senate update, and then let you all know what NACS is doing with the Main Street Privacy Coalition. The political landscape, I mean, in case for those of you who've been on an island and haven't had to read the newspaper or watch the news, God bless you all. Wish that was the case for me. Impeachment is beginning to happen, and that's taking a lot of attention on the House side. The hearings have started. Eventually, once the articles, if they pass the articles of impeachment pass, it's going to be going into the Senate. Every senator has to sit as if they're in a jury. So that's going to take away potential floor and committee time to work on laws. We're going into a presidential election. You have the entire House of Representatives up, a third of the Senate, and a presidential election all in 2020. It tends to be harder to do comprehensive, complex legislation in that type of environment.
Yeah, the number of days to devote
just the number of days. I mean, we barely can do a budget and appropriations work, much less trying to do privacy law. But so the likelihood of potentially getting something into law may be exceedingly slim to none chance in 2020. There's still going to be a lot of behind the scenes activity going on that's going to set the table going into, I think, 2021, where I think the next Congress, a year and a half from now, that's where you could potentially see a real likelihood of something becoming law. So
which might be after a number of other states have.
After a lot of states, and I think as we see some of the problems of implementing the California law and other states' activities, that may be another bit of momentum to do a federal law, do a good federal law, not just any federal law. Looking at the playing field and players, there's sort of key buckets of constituency happening. Obviously, there's consumer groups. There are sort of the tech service provider, information internet providers. You have data brokers, data collectors, obviously retail, Main Street type businesses. You have the healthcare, you have the telecom. So you have all of these buckets of interest that have their own unique perspective and not necessarily all getting along and in agreement of what privacy law, but they're all very powerful constituencies, which can also slow down the process, which may or may not be a bad or a good, maybe a good or a bad thing. So keeping that in mind, what we're hearing from committee staff and lawmakers is, when you look at the types of information that we're trying to deal with in privacy law, there's pretty unanimous agreement that if it is super sensitive information like your DNA, your social security number, your bank account number, your date of birth, and it's clear that that super sensitive information should not be misused and sold without consumer intent. So you sort of have the egregious examples and super sensitive information quadrant that everybody agrees that we need to protect that, we need to have a policy in place to do something. There's also agreement on less important information that's maybe used in a traditional business transaction that people don't care about. When you go and you order something on the internet, and I, order a set of towels, I know that that vendor is going to be using my home address to give it to UPS and FedEx or the US Postal Service to send that item. That type of normal business transaction, I don't need to opt in to have somebody use my address that's going to give me the product that I ordered. There's that general understanding, and that type of information, those everyday business people get it. So we're not really focused on that. Where it becomes more complex is sensitive information that maybe it's not a super important activity. What do we do with that? Do you intend, okay, yes, I have this sensitive information, but it's needed. We especially see this, say, with real estate folks and mortgage brokers. They're handling sensitive information, but it's implied that you have to use with a mortgage. So how do you let those normal businesses transactions happen with that sensitive information? How do you regulate and legislate that type of activity? And then the less important information, yeah, you might be selling the fact that I walk down, if I'm monitoring going down a certain aisle at a retail outlet and I'm picking, this shirt or this can of soup, or you're watching and monitoring my activity, it's not, you don't know who I am. I'm just a person walking down an aisle. So the information isn't sensitive, but that information could be sold and used somewhere else to look at marketing practices. How do you want to deal with that information? And so it's those unintended consequences that really is the trip up of trying to write a law that deals with the super sensitive information, but allows normal business transactions to happen. And that's why, trying to delve into those different examples when we're meeting with legislators are so important, because a lot of times like, well, I didn't mean to do that, or, that's not what we're trying to go after, or I had no idea that's how information was used. So the lack of, I think, education from staff and members of Congress is always eye-opening, but it's also an opportunity for us to tell our story. Some of the key, I think, policy issues that is definitely, is there going to be preemption of the state law? So making sure federal law preempts the states, that's important. The second element is, there are some folks that would like to leave a lot of these policy questions I just raised and letting the contract system play that out and negotiate that out. But there's one downside to doing it that way. Not all businesses have the same leverage or the equal negotiation power with some of these powerful third-party forces. I mean, if you think about it, 64% of our industry are single store operators. Do they really have the clout and power to negotiate with a Verizon who probably has a standard contract, or with, Facebook or some other or major data broker system? So you got to have, if you're going to allow something to be in the contract, you have to know that there is the sort of equal power of being able to negotiate. So that is a red flag for, a lot of folks in the retail community of, okay, not everybody has the same market power, so it doesn't mean you can't leave everything to a contract. You need something in a legislative framework. The other, important bit of information or principle is, how do we make sure, particularly in our industry and other retail, how do you make sure that consumers want to have loyalty and benefits and rewards programs? They're willingly signing up. They're proactively opting in to sign for those programs so they get those special deals and hear about that information. How do we make sure we keep that as seamless and easy as possible and a positive consumer experience, and making sure that those programs still move forward? And then how do you make sure that how you protect information is transparent not only to consumers but to all businesses involved, so everybody clearly knows what the rules of the road, and that making sure that everybody is responsible for their own conduct with that information. if it's clear what our responsibilities as a convenience industry are on privacy law, we shouldn't be held responsible for somebody else's misstep. We should only be responsible for the information that we have at that time, not for another industries who may or may not have as sophisticated of a policy as we do. And then that means we also need to make sure that statutory obligations apply to everyone and that there's no exemptions. So those are kind of the types of things that NACS has been looking at in other retail communities. And that leads me to what is actually going on in the House and Senate. There have been pieces of legislation introduced in both the House and Senate, but we have been told by the committees of jurisdiction, which I'll go into in a moment, that they're dead on arrival, that they're creating their own policies. So on the House side, the key committees to look at are going to be the House Energy and Commerce Committee, the House Financial Services Committee, and the House Judiciary Committee on it from the enforcement perspective. House Energy and Commerce Committee staff has said they have begun stakeholder meetings. They've been taking a lot of meetings from a wide swath of groups. They want to try and make it bipartisan. We've been told that both Democrat and Republican staff have been meeting regularly to lay out a process. It's not apparent that this is going to be something that's happening tomorrow, that they realize, that they recognize that there has to be a bipartisan, but also plenty of opportunity stakeholders to have a say in the process. And so they're working to hope either have principles or a framework, maybe not legislation, that could potentially be shared and get industry feedback. There's probably going to be a lot of hearings. On the Senate side, we thought they may be working a little bit faster. There had been a group of senators, particularly Senators Wicker from Mississippi, from the Senate, chairman of the Senate Commerce Committee, also Senator Moran from Kansas, and Senator Blumenthal, that they were going to be working on bipartisan legislation and a framework. At the last minute, Senator Maria Cantwell, who is the ranking member of the Senate Commerce Committee, said she cares about this issue and wants to be part of the process, but her staff wasn't as involved in previous discussions, so they are trying to get themselves educated. I think part of it is that they also want to see what happens in the home state of Washington, and so that process has slowed down. But again, there's that desire to be bipartisan and an open stakeholder process. And there has been hearings to date, and there's going to continue to be a lot more hearings. So that's what's going on in the House and Senate. As part of this process, it's always good to have lots of friends and build partnerships. So NACS was a co-founding member of the Main Street Privacy Coalition that's included other retail groups, certainly all our fuel and convenience retailers like Sigma, NATSO, PMAA, along with NACS, the restaurant folks, the hotelers, the realtors, home builders, the International Franchise Association. So a whole host of businesses that you find on Main Street, we're all coming together to work on it. We have 2 new members in addition to NRF, the National Retail Federation. We have the Retailers Leaders Association, RELA, and we have a big ad is NFIB, which is the national association that really brings together all small businesses who are of like mind to us. So that's a lot of information that we showed that we just threw in there super fast. I think, you know, bottom line is federal privacy legislation is likely, it's going to be slow. And the hope is that with all that's happening in California, we can learn from some of the challenges that they have in their law, that hopefully that won't be repeated at the federal level. Because you don't want to take any bill, it has to be a good bill for consumers and businesses. So
it's a shifting target to all of these various bills that you mentioned that are already out there, even if they are dead on arrival. They're all going in a lot of different directions, and California isn't even settled. The regulations that I mentioned won't be finalized until July 1st. So there's even a problem for us trying to figure out exactly what we need to do in California. And there's new legislation that likely is going to come in California. Do you want to mention that?
Well, there's also the original supporter of the proposition that started this cabal has decided that he wants to go even further on privacy law. So there could be another ballot proposition or put on the ballot in 2020, sort of privacy 2.0, that could complicate all of this even more.
Yeah, and a lot of that has to do with enforcement.
Yep.
In California. I didn't get a chance to show the slide. There is a slide that talks about enforcement for you to take a look at. Other than a breach notification violation, where there can be a private right of action, read class actions, all other violations of the California law are going to have to be done through the Attorney General, complaints to the Attorney General.
So we do have one quick question. We only have a few minutes left, but there is a question of how are payments processors and acquirers, how are they treated under the California law? I know in federal legislation, we want them to have to play by the same rules we do because we don't want to have that burden. But what happened in California? Were they exempted, carved out? Do they have to follow the same?
Oh, yeah, no, all payment is any information that is identifiable, reasonably identifiable.
But what about the Graham, Leach, Bliley exemption?
Well, that's banking. Yeah, that's banking.
But there are some processors, though, that are regulated under GLB or Graham, Leach, Bliley. So how do you treat an entity that is both a processor but also regulated, part of their business is regulated under GLB?
My expectation would be that they'll claim some exemptions, but the scope of those exemptions and how it will play out in a real life situation is going to be up to the Attorney General. And that's anybody's guess right now. And I can tell you with this Attorney General, who have already spent most of the summer trying to get legislation to make everything private right of action because he claims there's no resources for the Attorney General to enforce the law. My guess is the enforcement through the Attorney General will be sporadic and politically motivated.
So to wrap up, it sounds like we have a lot more to learn as we go through the implementation phase, that there are a lot of question marks. So we're better off being as prepared as we can to take the 5 recommendations you shared that don't, if you're in doubt, go ahead and have a policy, follow your 5 recommendations. And then it's just going to be a wait and see how all of these implementation determinations are followed. And then if you're not in California, you better pay attention to what's going on in your state legislature. So hopefully maybe you can avoid some of the downside of what happened in California. And then hopefully you'll be able to, when we're at the federal level, we can take all of those lessons learned and actually have a good federal bill that's good for the convenience industry.
Yeah, I would echo exactly those sentiments. Being prepared, and if you ever do get investigated, the place you want to be is
that you tried to do the right thing.
I'm prepared, I did all these things, here's what I do, and be in a position to defend any decisions you've made as to why your privacy policy is conducted the way it is.
So we don't see any other questions. It's been a pleasure to be able to talk with you all about privacy legislation. As you can tell, it's not easy, it's complex. I'm sure we're going to be having to do more of these webinars next year as we continue to learn more about what's happening in California in the implementation phases. And then certainly as federal policy moves, we will want to share those updates with you all. And with that, Allie, are you there?
I am. Thank you all so much for presenting. That was a lot of information packed into this hour. If anybody has any questions or any comments, feel free to reach out to us at info@conexxus.org, and we will make sure that your questions get to Alan and Paige so that they can be answered to the best of their abilities. Thank you all for all joining, and have a nice day.
Good. 12:59.
Yeah.